Good afternoon and welcome to today's webinar, Navigating the Legal, Economic, and Business Challenges of the Coronavirus Pandemic. My name is Michelle Johnson. I'm a partner in the Atlanta office and a member of the Employment Group. This afternoon, I'm joined by Keven Mekler from our Tampa office. He is a partner who practices in the areas of data privacy and security and incident response. We also have Hart, a partner in Atlanta, and Dylan Trache, a partner in Washington, D.C. And Lee and Dylan are in the Bankruptcy and Restructuring Practice Group. Next slide, please. Before we get started, I wanted to let everyone know about the Nelson Mullins Coronavirus Resources. We have a page on the homepage of the firm website, which is at www.nelsonmullins.com. If you have questions this afternoon, please email them to Amanda Miller at nelsonmullins.com, and we will follow up after the webinar ends. This presentation is being recorded, and the PowerPoint and a recording of the presentation will be emailed to all registrants after the webinar is over. So, the first topic that we're going to talk about today is ADA and FLSA considerations for remote workers. Given the new normal, which includes shelter-in-place requirements and the need for increased flexibility when balancing work and family, many companies are experimenting with work-from-home arrangements. There are many potential benefits to allowing employees to work from home. These benefits include increased productivity, employee retention, and improved morale. However, there are a number of legal issues that need to be considered. In particular, the Fair Labor Standards Act and the Americans with Disabilities Act both apply to the remote workforce. So the first thing I want to talk about today is the FLSA. And the FLSA generally divides working people into salaried, exempt, and non-exempt. So salaried exempt are employees who meet one of the duties tests under the FLSA, which is executive, administrative, or professional. They make a salary of at least $684 a week or $35,586 a year. They are not eligible for overtime. They're not required to track hours. The other basic category of employees are non-exempt. Non-exempt employees earn wages of at least $7.25 an hour under the FLSA and under Georgia law. Some other states have higher state minimum wages. And non-exempt employees earn overtime for hours worked over 40 in a week at 1.5 times their regular rate, and they have to track all the hours that they work. Next slide, please. With respect to salaried exempt employees, companies have a lot of flexibility with respect to the working arrangement. A salaried exempt employee can work from home for an unlimited number of hours. Salaried exempts can have their pay reduced as long as they continue to receive the same salary every week and the salary continues to be at least the minimum, which is $684 a week or $35,586 a year. A company could furlough a salaried exempt employee for full weeks and not pay them at all. But exempt employees have got to receive their full salary in any week that they perform work, even if they're not working full-time and they're not fully engaged. Another option for exempt employees is to require them to take PTO and pay their salary, but deduct it from their PTO bank. And finally, with an exempt employee, duties can be adjusted, but the limitation on that is that the exempt employee's primary duty must remain one of the executive, administrative, or professional exempt duties. Next slide. On the other hand, non-exempt employees can also work remotely. And there are a number of options that companies have with respect to remote work from the non-exempt. The non-exempt employees can work from home on a schedule set by the company, which is not necessarily the same schedule that the employee worked on before becoming a remote worker. Very, very important that they keep track of all hours worked, and they have got to be paid overtime if they work more than 40 hours in a week. If the company needs to reduce pay, it can do that as long as the employees earn at least the applicable minimum wage. Non-exempt employees can be reduced from full-time to part-time, and they also may be required to take PTO instead of working for a time. With non-exempt employees, because they don't meet one of the exempt duties tests, a company can change their duties at will and assign them whatever tasks need to be done without changing their non-exempt status. Next slide. So as you can imagine, there are a number of issues that may come up with a remote workforce. And the biggest question is, how do we track hours worked remotely? It's easy if somebody's in the office because you can see them, you know when they're there. But what do you do when someone's working from home? There is not any required way to keep track of time, but some recommendations might be to have the employee log in on their computer. They could keep paper timesheets and certify each week the hours that they worked. They can send an email to their manager when they start and when they stop. And so the way that time is kept is going to be a business decision, and it's going to depend on the workforce and what works for the company. Another question that comes up is whether the company has to pay for every hour between the first thing the employee does in the morning and the last thing they do at night. When someone is required to come to work and be in the office, that's exactly the way it is. They have a shift. They work 8 in the morning till 5 in the afternoon with a half hour for lunch, and you pay them for every minute that they are in the office except when they're taking their lunch break. When someone works at home, that's not required. If a company wants to pay someone for working a split shift, say 8 to 12 in the morning, and then they take some time off, and then they work 3 to 7 at night, that's fine. And you do not have to pay them for the entire day. You have to pay them for all the work they do, but it does not necessarily have to all occur in one 8-hour continuous period. Another question that comes up, what if the employee needs a computer or needs an internet connection or needs a cell phone? Who pays for that? The answer under the federal law is that the company can require employees to pay for their own equipment, provided that the cost of the equipment does not bring the employee below minimum wage for a non-exempt employee or the minimum salary level for an exempt employee. So, the advisability of having employees buy their own equipment is debatable, but legally, if the company wants to require employees to provide their own equipment, then that is allowed, again, provided that the cost of the equipment does not drop the employee either below minimum wage or below the minimum salary level. Another question that comes up is, how do you supervise somebody who's working remotely? Because some employees do just fine on their own, and others don't. And this is going to be an issue that's going to vary from company to company. And the best advice that we have is be sure that you over-communicate. Talk to the employee, check in with the employee at least daily or more often if that's necessary. And you can do that via phone, email, text, chat. You may have technology that permits a video call. And it's just going to be a business issue as how much supervision the employees who used to work in an office but now work at home need. Sometimes an employee's job cannot be done outside the workplace. For instance, somebody who sells shoes at Marmy or Payless. The only thing they know how to do is sell shoes. And if they cannot sell shoes in that store, then their job can't be done. And if that's the case, that's unfortunate. But a company is not legally required to provide remote work if a job just cannot be done outside the workplace. What about time spent reading and responding to emails and texts? For exempt employees, it doesn't matter. They can be emailed or texted anytime, day or night, and they won't get overtime. They get their salary, and that's what they get. Now, with employees who are non-exempt, it's another story. And there has been a lot of litigation about employees who receive texts and emails over the weekend or short calls, and they felt that they were required to take those messages on their off time. And especially with the remote workforce, if a non-exempt employee is sent a text or an email, they need to be paid for that time. So you can handle it two ways. One is to tell the managers not to be sending that stuff outside of the workday, and tell the employees they are expected not to be responding to emails and texts unless they are during their specified work hours. The other option is to let them text and email anytime, but pay them. You got to pay them for that time. And then one other issue that does come up is childcare. We have got a lot of schools that are closed, a lot of childcare and daycare that's closed. And there are a lot of kids at home and parents who are trying to work at home. And I think it's happening to all of us. And it can be a touchy situation because people that have kids don't have any choice. If they're working from home and the kids are at home, there's not a lot that they can do about that. But there are some alternatives, one of which is to have someone who has small children work early in the morning before the kids get up, and then have the kids e-learning and digital learning and going to school online, and then have the employee pick up their job later in the day, maybe after the kids have gone to bed. That's one option. Another option may be to move somebody from full-time to part-time so that their schedule can correspond to the time they have to spend with the kids. It's a problem, but the company is not required to allow someone to work remotely without considering the child care issues. There may be client calls and supervisory meetings and things of that nature that have to be done and require someone's full attention. And in those cases, I recommend having a frank discussion with the employee and trying to work out something that works for everyone, keeping in mind that the kids are there, but the job has to be done, and try to figure out a solution that allows the employee to be a parent and to do their job. Next slide. we get a ton of questions about home offices and OSHA. And fortunately, I have learned that there are no OSHA regulations regarding home offices. OSHA does not inspect home offices. As a matter of policy, they will not come out to your house and look at it. OSHA does not hold companies liable for home offices and does not expect employers to inspect a home office. That's just not something that OSHA does. However, if somebody gets hurt at home and it's a work-related injury, companies are required to keep records of the work-related injuries and the illnesses that occur in a home office. One other tidbit, on April 10th, just a few days ago, OSHA issued modified reporting requirements. And this may not have a lot of application if you have your entire workforce working remotely. But if you do have people that come into the office, OSHA has said that it will not require companies to inquire as to why one of their employees has COVID-19. Reporting of a COVID-19 diagnosis that is work-related is required. And it's work-related if the employee obviously got it at work. If the company knows that, then they do have to put that on their log. But what they don't have to do is to be a detective and try to figure out where the employee got the COVID. They can just let that go. The exception for this is healthcare, emergency response, and correctional institutions are not subject to the relaxed reporting requirements, and they have got to make the work-relatedness determination that was previously required. But the good news is for everybody else, you don't have to. It's not required right now. Next slide. So we also get a lot of questions about the Americans with Disabilities Act, because working from home can be a reasonable accommodation for any number of employees. And particularly now with COVID-19, first thing is if somebody has it, you can send them home and make them stay home. That the ADA does not prohibit that in any way. With respect to employees who may be at a higher risk for COVID-19, working from home can be a reasonable accommodation for them. There are a number of conditions such as diabetes, cancer, other illnesses that cause someone to have a recognized disability, and they are at risk if they contract COVID-19. So that category of people may need to work from home as a reasonable accommodation. Another category of people are those with pre-existing mental health conditions, and maybe they're just fine working in the office under ordinary circumstances, but the pandemic has aggravated their condition, and now they need to work from home. And when you get a request like that, the company is required to engage in the interactive process under the ADA and talk with the employee and figure out what is reasonable and what can they do to allow the employee to perform their essential job functions. They don't have to perform all of their functions. So marginal job duties that can't be performed at home can be restructured and assigned to somebody else. For example, if someone is a executive assistant, they can't very well make copies at home. So making copies may be somebody else's job for a while. And then the other point is that sometimes you have employees who are already getting a reasonable accommodation at work, and they may need a different accommodation if they're working from home. And one example might be someone who is visually impaired, and when they're at work, they have an assistant who reads the mail to them. Well, when they're at home, the assistant isn't at home with them, and so they may need a different accommodation, such as having the mail sent to the coworker, and then the coworker calls them and reads it to them over the phone. So it may be just as simple as that. Next slide. The other main issue under the ADA is potential discrimination claims. The one issue is if everyone can't work at home, how do you decide who gets to do that? It would be unlawful to discriminate on any unlawful basis, including the existence of disability. So you cannot arbitrarily furlough everybody with a disability rather than giving them the same consideration for work at home as you gave to anybody else. In order to ward off a claim of discrimination down the road, it's important to document the factors that were considered in deciding who got to work remotely and the evaluation process. So some of the factors that may be considered is whether people already do this job remotely. If you have people that already do it from home, then chances are good that it's a reasonable accommodation that makes sense for other people to do it. Is this the kind of job that can be done without one-on-one direct supervision? Is it a job where in-person interaction is not essential or can be accomplished with technology? Next slide. So to summarize, working at home can be a good thing. It can really help with productivity. It can help keep the business going. If you decide to institute a work-at-home policy, then best practices are, first, have a written policy on bring your own device. Have a policy on who pays for it, what the device is, any other factors that need to be considered. You need to have in writing where the work can be done. Does it have to be done at home, or could it be done in a coffee shop or some other public place? It's important to have that decided ahead of time. And then the other important information to have in writing is the hours and the days that work is expected to be done. And that's particularly important with non-exempt employees because you want to be sure that later on they can't claim that they worked different hours because they didn't know what hours they were supposed to work. Again, strictly enforce the policy against off-the-clock work for non-exempt employees. Have a safe harbor policy. And a safe harbor policy says that if the company makes a mistake in somebody's paycheck, it's up to the employee to bring that to management's attention. And once they've done that, it will be fixed. That's really important to have a policy that lays out the procedure for getting a mistake on your paycheck taken care of. And then finally, if employees are working remotely for the first time, it's important to make sure they understand how the job is going to change. How are the duties going to be different? What are the expectations regarding contact with the supervisor? How often is that contact going to occur and how? And particularly, how will productivity be measured? That's really important for employees to understand on the front end. Moving on, Keven Mekler is going to speak now about cybersecurity risks with a remote workforce. Take it away, Keven.
Thank you so much. So Keven Mekler, I'm a partner in the Tampa office and focus my practice primarily on incident response work, also do privacy and cybersecurity, which tend to overlap with it. So this the purpose of this presentation is going to be really dealing with cybersecurity issues and how those have been impacted and changed with regard to the quarantine and what's happened now with COVID-19. Next slide, please. So starting off, I think the most important place is you can go and you can look and find 1,000 different definitions of cybersecurity. I try to think of it in the most simplistic form and just say it's in essence, it's the way you protect your systems and your data from the risk of an unauthorized access, loss, corruption of that data, or destruction of that data. This has really been something, using a very simplistic definition like this is something that has really been exacerbated by the whole work at home. You've taken something that was centralized and you have moved it out to its weakest point, and we'll discuss that as we kind of move forward here. But cybersecurity in general is just accomplished through controls. Controls are always going to be looking at your people, looking at your processes, and looking at your technology. So the people are going to be the ones that are going to be the employees, the staff, that can also be consultants and outside sources that you've contracted with to assist in that. The processes, mostly dealing with your employees again, is how they're going to be trained and understand the way that they manage data, the way that they manage information within your systems and environment, understanding the controls that are in place and actually applying them. And then technology, obviously. We're talking about computer systems for the most part when we deal with data. The technology is going to be that infrastructure that is going to be in place to try to protect this information. I have on the slide something that I usually look at, and you've seen it applied to 1,000 different scenarios, but you look at that 80-20 rule. And the 80-20 rule really is, in this sense, it's the people are going to take up that 80%. The 20% is the technical solutions. But you can have the greatest technical infrastructure, and if you have a breakdown in your people and in your processes, the technology is not going to stop the threat actors from either accessing or acquiring or corrupting or destroying your data and your computer systems. If we'll go to the next slide, please. So looking at this, what I call the State of the Union, the real storm of events that has occurred when it comes to the cybersecurity and what's happened is the companies across all industries were in a position of operating in either without a remote workforce or some varying degree of having a partial remote workforce, having some people working out of the office, being able to travel, still being able to be connected, being on the road. So they had a limited amount of remote workers. And then the switch was flipped, and companies were given the option of either shutting down or finding a way to have people working remotely. The problem with that is when I looked at the controls and you talked about the people, the processes, and the technology, unfortunately, the people are typically the easiest targets for threat actors to exploit in order to get into your system. That is in essence, the weakest link in the chain is going to be the employee side. When you take that and you move it away from a centralized environment and you now move them into a remote environment somewhere else, you're moving them further away from the security. So you're weakening what is already the weakest link with going to a full remote workforce. The other issues that arose when this switch was flipped was there was no ability for companies to take the time to do advanced planning and implementation of new processes or new technologies. In essence, it was we need to keep moving, we need to get people out, we need to keep them working, and they can't be in this building. And so in a normal sense, if companies were looking to move to more of a remote workforce for whatever reason, they would have the opportunity to have specialized consultants come in, take a look at their environment, help them build it out in a secure fashion, build it out appropriately in order to accommodate remote workers. In this sense, there was very limited time to do that advanced planning and even less time to do any implementation of any new solutions or new processes. Likewise, you have people that have been accustomed to getting up in the morning, driving to an office, and sitting within that environment where if they have an issue, they can ask somebody, but they're used to working there and then turning off their systems and going home. Now you have people working in this new environment, and there was very limited opportunity to train them, to get them more aware of security concerns, to get them more aware of risks, to train them on how to operate within their own home environment, to ensure that they have their network set up in a secure fashion, and just to essentially guide them and give them the awareness. In other words, the same thing. The switch was flipped and people were sent out to do their job in a completely different way without having an opportunity to be trained. Another concern is now, because you didn't have the time to advance plan or implement new solutions, you have a lot of companies are operating with overstressed systems. They were not designed to have this many remote users. They may not have the necessary bandwidth to function and have these users coming through. But in any event, again, it goes back to that planning and implementation. The systems are overstressed. They may be bogging down. You're losing productivity essentially on one side of it because the systems can't handle it. But it can also open up a host of concerns if the system goes down, if the system crashes, trying to bring that back up, and it can open up also security concerns because of that. And the last one I put on here is communications. This was another change that is now part of our State of the Union. For years and years, obviously, we are a very electronic society. Everybody carries around, everybody functions by email. We're used to texting. We're used to those electronic communications. The problem is now we are almost exclusively reliant upon them. So you don't have the face-to-face conversations. You don't have people being able to walk to the office next door. You have more people now that are exposed to these new technologies, so they have not done video conferencing before. So they're excited about that. They want to use Zoom. They want to use GoToMeeting. They want to use WebEx. They want to use Skype. Whatever those are, that is something new and exciting. Each one of those brings a security concern ahead of it. And so we've now taken yet another piece of this and changed it for the worse when it comes to cybersecurity by forcing everybody to be communicating almost exclusively electronically. Next slide, please. So if you go back to, again, the initial slide of talking about protecting systems and data from risk of unauthorized access, loss, corruption, or destruction, this current trend slide is telling you exactly what the threat actors, and these are 4 trends as part of our incident response group. These are primarily the 4 that we see day in and day out. When you tie that back to what we talked about with people and controls, you'll see most of this is going to be accomplished by trying to exploit that weakest link in the chain. The threat actors are out there, and the threat actors know that this is the environment we're working in. It's global, right? So if you had everybody working in a tight space, everybody was there, you had it under one roof, you had your security measures in place, the processes were in place to function in that environment, you're going to hopefully be in a better position to thwart off some of these things. Now that we've spread people out, these 4 current trends are actually, they're increasing, and it's just become again something that has not only increased in a general sense, but is now increasing again simply because of coronavirus. So what we're seeing is an uptick in trending from threat actor groups that are using coronavirus to bait people into phishing emails, to bait people into clicking on malicious links, clicking on malicious documents or malicious attachments that'll have in the title somewhere coronavirus, COVID-19. Similar to, you look around and you're on a webinar here. This is a webinar series that is designed to assist people because of new issues and new threats and new things that they're facing because of that. This is real. You go and you can take a threat actor will take the same type of thread and send it around. And going back, because again, communications are all electronic, there is no one there that is face-to-face having a conversation to talk about it, make sure that it's okay to ask. Maybe they've emailed something to their IT person who's also working remotely, and they haven't heard a response, so they just go ahead and click on that email. It turns out to be a malicious email. And the result of that is what you see here on these current trends. So I'll walk through them kind of one at a time for those of you that have not, hopefully have not had to deal with this before. In no particular order, ransomware. Ransomware is, for lack of a better way to state it, somebody coming in and through malicious code locking up your system. And it can be just encrypting all of your files, or it can be encrypting an entire disk, like whole disk encryption. But in other words, you have no access to anything that you're working on. You cannot access, and depending on how how much encryption is placed or the type of encryption, it can shut down email, it can shut down your file structure, it can shut down your ability to function. And the purpose of that is essentially for them to force you to pay a certain amount in ransom in order to get that key to unlock everything. There's a new wave of that now too, where they are actually exfiltrating data, and they take that data away. And so if you have backup systems in place and you restore your data, they will still try to extort you by saying, if you don't pay me now, I'm going to release all the sensitive information that we've already taken. In either way, ransomware is very expensive. It is very timely. It can knock a system down even if you have sufficient backups. It can knock you out of business for several days at a time, if not longer, without those backups in place while you try to negotiate and get the system restored. The remote access scheme is another one, and I think of this especially now working in this type of environment. What we've been seeing a lot of is having employees receive phone calls from someone purporting to be either a vendor, a trusted source, so it could be your outside IT vendor or somebody that is one of your software partners. Somebody will be calling up one of your employees and impersonating one of those folks. They will have just enough credentials to say, I am who I say I am. And what they will do is say, there's a problem with your system. I need to remote in and fix it. They will gain the trust of that employee, and that employee will ultimately go and follow their instructions to go online and download something similar to like a WebEx, or to these you can have a log me in. There's a series of different software, but they'll download those to their network, and they will hand remote access to a threat actor who now has unfettered access and ability to maneuver throughout that particular computer system, and also to exfiltrate information and data from that system. We've seen this quite a bit over the last several weeks. It's been around for a long time. It just seems to have picked up, and I think part of that is with people not working in a centralized location. It's not going to be uncommon for them to receive a phone call or get an email and respond to it from somebody who would have been, a vendor or a third-party contractor that's working with them, and they will be following those instructions to give somebody and actually hand over access. The last two, I think you somewhat tie together, is the Office 365 and the business email compromise. They are two different things, but they do tend to go hand in hand. Essentially, we all work with some form of an email platform. Office 365 happens to be a very common one and a very strong platform that has a lot of functionality. One of those functions within O365 is the ability to set up various email rules that enable you to, without you having to do anything, automatically move emails that are coming in and move them into separate folders, to take them and put them automatically into a deleted folder. It's just a way of organizing your email. It also gives you the ability to forward emails automatically if they come from a certain source to an external domain. What's happening here is there's, if you go onto the dark web, you can buy as many credentials as you can possibly imagine. Folks are using these credentials and gaining access into the system. They're setting up those rules so that employees don't know that this is actually happening. So emails are automatically being moved, and they'll set those rules up using a set of series of search terms, things like ACH or wire or transaction, whatever they want to do. As soon as an email comes in with one of those search terms, it'll automatically get moved over into either an archive folder or into an RSS feed. And only the fraudster knows that that's happening, so they can actually follow through transactions. Also, even without purchasing those credentials externally, if an employee receives a phishing email, same type of thing, oftentimes they will click on that. They will be asked to enter their credentials, and they'll do so thinking it's legitimate. And what they're doing is essentially handing their credentials over to a bad guy who can then come in and do this. The reason that they do this is a couple-fold. Number one, what they're looking for is data. They can see if I get into the right email account, maybe I hit a CFO, maybe I get a controller, somebody that has a lot of financial data. I have full and unfettered access to that, and I can exfiltrate that information and I can use it. The other reason they use it is for this social engineering fraud or business email compromise. And ultimately what I'm doing there is I'm gaining access to your system so that I can then trick somebody else. And so if I get into somebody's network, I'm looking through their emails, and I see that they have a transaction where somebody is about to make a payment to them of $1 million. I can actually inject myself into that conversation without the employee knowing, send emails to the other side, and redirect that payment to myself. So I can now have somebody believing they're making a legitimate payment for whether it was services or goods, but they're making it to my fraudulent account. These are the 4 primary things that we're seeing and we're dealing with on a daily basis. They all have statutory and regulatory issues that may come along with them. The reason I put this up here is, again, if you start thinking about the security that people have at their homes versus when they're in the office, thinking about whether that has been set up appropriately enough to allow proper security as it's when people were starting to work outside of the office. The further away you get, the easier it is for me as a fraudster to go and exploit one of those employees in that remote environment. Next slide, please. Actually, if you go one more, it'd be great. This is actually a presentation that can take a much longer period of time and walk through in a much more step-by-step fashion. But in a nutshell, if you take the last slide here and just kind of look through the takeaways that are on this particular slide, understand that the data incidents and the things that I described, they have absolutely no tie to any particular industry. They can work across all industries. They affect all businesses, any businesses that have employees, any businesses that are working on computer systems. It's never too late to try to hit those plans. The light switch was flipped and all of this had to happen, but now there's a time to pause and understand, okay, we've been functioning for a couple of weeks in this environment. Let's take a step back. Let's take a look through our incident response plans. Let's see what our infrastructure looks like. Let's do some vulnerability testing. Let's make sure we have appropriate backup strategies in place if we are hit with ransomware. The other piece of it is don't forego this now, because companies are getting into a time where money is a little bit tighter. People are concerned about how it's going to look. And it's an easy thing to say, yeah, we're not going to do any upgrades. We're not going to deal with that. I'm worried about keeping the doors open. The problem is, if it happens to you now, it is much more difficult to handle than it was 30 days ago or 45 days ago, because everybody is spread out. It's more difficult to actually do the investigations, and the impact of it, if you're already financially concerned, is going to be much greater than it would have been. So the final takeaway is really do what you can, do it when you can, but just be sure to do something. There are simple things that really have no dollar sign attached to them. Train people, get them accustomed to this, give them the awareness. Make sure your password rules are set right. Make sure that the passwords have to be a sufficient length and that they're being changed at shorter intervals. And if you can, enable multi-factor authentication. It's available. It may be, some cost associated with initially getting it implemented, but it gives people, it gives you an added layer of security so that if your credentials get out there, that's not the key to get in. They need the secondary piece of it, and that will thwart a large portion of these phishing scams, a large portion of the things that I identified in the prior slide. So the key is really just do what you can, when you can, but do something. And start to systematically think through more on the cybersecurity side, because if it's going to hit now, it's going to be worse than it was, again, 30 to 45 days ago.
Thank you, Keven.
Thank you.
So our next speakers are Hart and Dylan Trache, and they're going to talk about bankruptcy during the pandemic.
Yeah, hi. This is Hart. I'm a partner in the Atlanta office in the Bankruptcy and Restructuring Group of Mullins. And Dylan and I are going to talk about, you see from the title slide here, bankruptcy during the pandemic, opportunities and pitfalls. And, we want to emphasize that bankruptcy is a thing that is used to is a tool that is used to help businesses restructure their balance sheets when their debts get out of whack with the business's operations. And so, obviously, along with the health concerns, we're all waiting to find out what the economic damage of this nationwide economic shutdown is going to be. And the restructuring and bankruptcy professionals believe that there's going to be a big role for the bankruptcy laws there in helping sort all this out on the other side. So Dylan and I are going to focus over the course of the next couple slides on the state of Chapter 11 now, and we're going to talk primarily about business bankruptcy and reorganization in Chapter 11. So we're going to talk about the state of Chapter 11 now, the state of Chapter 11 that we anticipate as we go through the crisis and the shutdown, and then what we anticipate the opportunities and the pitfalls of Chapter 11 are going to look like, both for large and small companies going forward. So with that, I'll turn it over to Dylan to talk about what he's seeing in the marketplace now.
Okay, thank you, Lee. This is Dylan Trache from the DC office, and we wanted to start with Pier 1. This is something that's happening in real time in many retail bankruptcy cases across the country, and I think most people know that retail was struggling even before the pandemic, and now even more so. The model for a retail bankruptcy case is pretty simple. You get rid of your bad stores, do store closing sales, and you try to reorganize a core group of performing stores. There's often some in the middle that you try to negotiate some deals with landlords to get better terms, but the basic premise is that keep the good stores, get rid of the bad stores. And because of this, landlords have, over the last 25 years, every time there's been an amendment to the bankruptcy code, they've been given more rights. They've got a powerful lobby, and they've got strong provisions in the bankruptcy code that require payment of rent, particularly after a bankruptcy is filed. But now, in light of COVID-19, what we have is bankrupt entities going to the bankruptcy court saying, hold on a second, this isn't working. We can't do our store closing sales because we've had our stores closed. We can't even pay for the electricity to stay on. We can't do anything. They've called it mothballing, and what it is an attempt to make basically only the very critical payments that are required to essentially keep the company operating. And so many of the employees have been furloughed. They're not going to pay rent. They're not going to pay their vendors. And it's really distressing if you're representing a landlord in a Chapter 11 case. And another reason this is interesting is that I think it sort of forecasts some of the arguments that companies are going to make to attempt to avoid paying rent in non-bankruptcy scenarios. So, for instance, we use the Pier 1 motion as an example, and what they argued is that, one, the bankruptcy court can do this. It has general equitable powers. We need a breathing spell, and give us some time off until this pandemic subsides, and then we'll get back to paying rent. But the other argument that they made is that the stay-at-home orders are really government takings, rendering the impossibility and frustration of purpose provisions of the lease operative such that they don't have to pay rent under the terms of the lease regardless of the bankruptcy. Now, it's important to note that the Pier 1 form leases don't include force majeure clauses. That would probably be the first place that one might look if they were looking to avoid paying rent. But they didn't have those, and so they were forced to look at other arguments. I attended a hearing last week where landlords jumped up and down, complained about it, but at the end of the day, the bankruptcy court granted the motion, and essentially said, look, I'm going to give them 30 days here. Let's come back at the end of the month and see where we are. I'm not going to opine on these lease-based arguments that rent is not actually owed, but the stores can't operate right now. You can't do going out of business sales. You can't operate as usual. And so let's see where we are in 30 days, and we'll just ride this out for however long it takes. And so that's really the Pier 1 situation. And there are other cases, Modell's. In fact, the True Religion Jean Company filed bankruptcy yesterday and immediately filed a similar motion saying, let's hold off on everything. So that's sort of the state of retail bankruptcy as it exists today. And we can move on to the next slide.
Yeah, so shifting from the large cases for companies with household brand names that we all have heard of, or stores that we've probably all been to, shifting from those sort of mega cases down the gradient to what's happening in small business. Concurrently, but not necessarily related to the COVID-19 pandemic, at the end of last year, after what was a couple years long push by bankruptcy practitioners and small business lobbies to simplify and render more effective and efficient the Chapter 11 process for small businesses, Congress passed the Small Business Reorganization Act of 2019. They passed that on August 23rd, and there was a couple months lead time before that went into effect, and sort of, coincidentally, it went into effect on February 19th of 2020. So, literally just a couple weeks before the economy started to shut down because of the pandemic. And the concept was that, Chapter 11 had really grown from what was hoped to be an effective way to reorganize a balance sheet to, just a venue for every constituency of the business to hire a lawyer, come in, throw up an obstruction, drive up costs, and negotiate their position. And while that is a strategy that, and a set of circumstances that may really make sense for very large publicly traded companies, for the smaller mom and pops, it effectively made Chapter 11 not a viable option because of the expense. So what we want to do is talk a little bit about the Small Business Reorganization Act, the SBRA, what it did for small businesses, and and how it's streamlining things entirely outside of the pandemic. So next slide, please.
Okay, and so who is eligible for this SBRA? It's a person engaged in commercial or business activities, and the Bankruptcy Code defines a person as basically everything other than a governmental entity. So you can be a corporation, an LLC, you can even be an individual who's acting as a sole proprietor. All of these are eligible for the SBRA. Now, what is not eligible are publicly traded companies and single asset real estate debtors. That is an entity that solely holds one piece of real estate. Those are very common bankruptcy cases, and there are special rules that govern single asset real estate debtors. But there's a debt limitation. The debt limitation, at least when the SBRA was enacted, was $2.7 million. So contingent or non-contingent, liquidated, secured, and unsecured debt could not exceed $2.7 million. And so it really was geared towards the small business, the mom and pops that maybe had one or two locations. And importantly, at least 50% of the debt had to arise from the commercial or business activities of the debtor. So if you do have a sole proprietorship or an individual that's conducting his or her own business, at least 50% of the debts owed by that person have to be commercial in nature in order to qualify for for the Act. And if you have some affiliated companies, those debtors' debts are aggregated to determine whether the $2.7 million threshold has been reached. Next slide.
So what does the SBRA actually do? What is it actually changing? Well, one of the big hurdles to filing bankruptcy or successfully prosecuting a Chapter 11 case from the perspective of small business was what was called the absolute priority rule. And what it said was that the prior owners of the company were not allowed to retain their ownership in the company unless either they paid all their creditors in full, which presumably they couldn't do because that's why they wound up in bankruptcy in the first place, or unless they essentially bought their equity back from the bankruptcy court after a fight as to whether or not they were paying enough money. And so clients would often say to us, well, this is a great option, this Chapter 11 thing, but I just don't have the money, any more money to put into my business to keep the equity. And because I'm not going to file Chapter 11 to give away my business, it's just not viable. I want to own the business on the other side. And so what the SBRA does is it recognizes that for small businesses where your closely held management team owns the company before filing and wants to own the company after filing, the absolute priority rule needs to be eliminated. So they did that. But the requirement that they inserted instead is a payment of disposable income requirement. So now, rather than having to buy back your equity from the bankruptcy court, you just have to promise in a plan that all of the disposable income of the company for a period of 3 to 5 years after exiting bankruptcy will be paid to your creditors pursuant to the plan. And of course, all of these concepts are brand new, so we don't really know specifically how disposable income is going to be calculated or what's going to be included in disposable income. But it's a tremendously beneficial option for closely held companies now, in that they can go ahead and get a plan confirmed and retain ownership of the company. We're just going to have to work out the details of what exactly disposable income means.
Right, and as we say here, there's no appointment of a creditors committee. That's one of the main expenses in a Chapter 11 case. If there's a creditors committee appointed, the debtor is basically paying for not only its own professionals, but those of a secondary entity that are not necessarily aligned with the same goals. So lacking a creditors committee can help facilitate the limited expense and also the speed that a small business can go through bankruptcy.
Yeah, and so then speaking of speed, the Chapter 11 cases are notorious for just lagging and hanging around for what seems like forever, especially to the creditor body. Under the small rules before the SBRA, the debtor's requirement to file a Chapter 11 plan, but the debtor had 300 days to file a Chapter 11 plan if the debtor was a small business. That for an SBRA case has been reduced to 90 days, which is really an indication that the law wants to see these businesses get into bankruptcy court, negotiate their issues, and get out as fast as they can.
And for that reason, there's not a separate requirement that a disclosure statement get approved before a plan is solicited for voting. They're really trying to streamline this practice and allow things to go through very quickly.
Yeah, and the streamlining itself is facilitated or supposed to be facilitated by this brand new Subchapter 5 trustee, which is a completely new creature of law. This is a person who's going to sit on a panel in every district, a panel of people in every district, who will be chosen by the U.S. Trustee's Office to facilitate the development of a consensual plan of reorganization. So it is basically a mediator, a government selected disinterested mediator to attempt to resolve the various differences in the case to bring together the parties under a consensual plan and minimize the fighting and the expense. Next slide, please.
Okay, and so the CARES Act, which was recently passed by Congress in an attempt to mitigate the downside of this pandemic, at least for 1 year, has increased the debt limit to $7.5 million. And so this is not only now a Small Business Reorganization Act, but you can see a business with $7 million of debt. That's not that small, and so allowing these more medium-sized businesses access to the act will hopefully allow some very quick restructuring activity in the coming year. Next slide. And as we try to finish up here, we do expect that bankruptcy activity will be a little bit slower during the pandemic. Courts are not going to be anxious to hear many non-critical matters. You may see various bankruptcy cases go in, have their what we call the first day hearings on getting your employees paid, and then shutting everything down. As I mentioned, True Religion Gene Company just did that yesterday. They filed their motion to just shut everything down for a period of time. There may be some government financing available. We'll have to see how the CARES Act interplays with bankruptcy. And I do think we'll see some credit accommodation from lenders and landlords. We've already seen a lot of prearranged filings, particularly in the energy sector. A lot of the cases going in right now are so-called prearranged bankruptcies where essentially the equity is getting wiped out and the bondholders are taking over the company. So we do still have bankruptcy going on during the pandemic, but although there is currently a fairly good volume of cases, I think that will probably slow down over the next month or so. Next slide.
Yeah, so the question is going to be what the sort of longer term horizon looks like for the economy, and how the bankruptcy system is going to help facilitate the recovery, or at least the sorting out of the damage. As Dylan said, there seems to be a fair amount of volume now, but the wave of cases has not hit us yet. It's anybody's guess when that happens. We're all sort of looking at a 8 to 12 week horizon for that to happen. But various things to think about from all the various sides in connection with, what we all anticipate to be an uptick in bankruptcy filings. And these are things that are applicable to troubled businesses, but also to folks that are supplying those troubled businesses, and to opportunistic investors who are looking to unlock value in a down economy where the prices are just less. With respect to these, with bullet points 2 and 3, reclamation claims and 503b9 claims, these are claims that you want to pay attention to if you are a supplier of goods. With respect to reclamation claims, what that means is if you have shipped product to a business that is insolvent, you can actually get that product back if you take swift steps to demand it. Outside of bankruptcy, your requirement is pretty fast. You have to send a written notice to your customer demanding the product back within 10 days after they receive the goods. And that is subject to an exception that if your customers told you that they have no solvency problems and they're in great financial health sometime in the prior 3 months, then that 10-day requirement goes away. Conversely, if there's an intervening bankruptcy case, your reclamation time period expands to 45 days, looking backwards, so 45 days prior to the bankruptcy filing. There are some details around the edges there, but the point is that if you're a shipper of goods and you suspect your customer is insolvent and on the brink of bankruptcy, you ought to consult your attorney as quickly as possible so that you can find out whether or not you can get your goods back so that they don't get tied up in the bankruptcy estate. A 503b9 claim is really bankruptcy jargon for a higher priority claim that you can get paid in whole dollars to the extent that you've delivered goods within 20 days before the filing. So if you deliver $150,000 worth of goods to a customer and 2 weeks later they file bankruptcy without ever paying you your $150,000, you actually have a good claim for that $150,000 in the bankruptcy case. To the extent that there's money available, you should get paid that money dollar for dollar before the general unsecured creditor pool gets their money. So important things to think about if you're in the business of supplying goods and you suspect insolvency in your customer base. Roles to play for opportunistic investors. You know, if you're in the business of investing or lending money, or if you're looking to grow and your balance sheet is healthy, there's a lot of different roles that you can play to catch the bankruptcy wave when it comes through. DIP lending is a big one that a lot of people talk about. That stands for debtor in possession lending. It's essentially making a loan to a bankrupt company so that they can function in the bankruptcy case. There's a number of different reasons you might want to do that. The pricing is obviously much higher, so you can do it for return. You can also do it in connection with an asset purchase if you want to utilize your DIP loan to buy the assets. Rather than DIP lending to finance the company in the bankruptcy case, you can also be an exit lender and come in and say, look, I'm going to provide you a pathway out of bankruptcy with a new loan. I'm going to pay off a pre-negotiated amount of your pre-petition debt. And then the debtor takes basically your term sheet into the court together with a Chapter 11 plan and seeks confirmation. And if it's a confirmable plan, then you make your loan on confirmation, and now you're the new lender. And you never have to touch the company while it's in bankruptcy, which is something that a lot of people really like to do. And then finally, there's just a good old capital injection. If you've got a bankrupt company that you think has legs and you want to be part of the solution, you can certainly, rather than being an exit lender, you can be an equity partner on the way out of bankruptcy, likely purchase the equity or some large part of the equity for a very favorable price, and have the plan confirmed, and then own the business or most of the business from there on out. So that's another advantageous way to generate value in these circumstances. And, I just would encourage everybody in that position to keep their eyes open because, there's certainly opportunity in every crisis.
Well, thank you, Lee and Dylan.
Yeah.
Didn't mean to cut you off there. Sorry.
No, go ahead. I was going to say that concludes the bankruptcy portion of the presentation, and thank you all for listening.
All right. Next slide. So thank you, everybody, for joining our webinar. And we are, remember, going to email the recording and the PowerPoint when they're available. If you have questions, send them to Amanda Miller at nelsonmullins.com. And have a great afternoon.